Thank you so much for coming out this evening to celebrate our extraordinary honorees and, of course, the important work of the Office of the Appellate Defender. As you know, OAD's mission is to provide outstanding appellate representation to poor people convicted of felonies in Manhattan and the Bronx, to improve the quality of indigent defense representation through education and training, and to advocate for systemic reform of the criminal justice system in New York City. In the last year, we excelled across the board. Our lawyers achieved numerous outstanding victories in court, including the vacatur of 25 convictions for a young woman with a harrowing history of abuse at the hands of 2 sex traffickers, which began when she was just 12 years old, including the vacatur of a life without parole sentence for a young man with an extensive history of mental health problems that dated back to when, at 7 years old, he was found living under a boardwalk, covered in scabies and lice, and only able to communicate in grunts and screams. As wonderful as these wins truly are, we do not count our successes solely in terms of courtroom victories. It is equally important to us that we had face-to-face meetings with over 100 of our incarcerated clients across 28 upstate prisons. More than 70% of the clients for whom we provided parole advocacy support were released from prison. And our in-house social worker processed 84 referrals for assistance, overwhelmingly asking for reentry support. This truly unique form of full-service appellate representation is what we are talking about when we say we represent. And we cannot do it without you. I am incredibly proud to say that this year we have raised $550,000. Because of the people in this room, OAD not only demands full and equal access to justice for everyone, regardless of race or gender or economic status, we also maximize individual opportunities for success and help break the cycles that contribute to mass incarceration. With an additional $50,000, OAD can deepen its capacity to provide holistic appellate representation and break a fundraising record. So I would like all of you to open your journals. Inside, you're going to find this card. Next, I'm going to ask you to take out your phone and turn on your camera, and then you're going to aim your camera right at the center square. What will happen is a link will pop up that will take you exactly where you need to go to support OAD's work right now. I will not be offended if I see you looking down at your phone for the next few minutes while I'm speaking. Because what I would love to do is for us to make history tonight. Before I introduce our Master of Ceremonies, I want to offer my personal thanks for the people who have made this evening so special. Our advocates and the recipients of the Gould Award for Outstanding Oral Advocacy, Faith Gay and Judge John Gleason. Our Chief Justice and recipient of the OAD Council for Justice Award, Tony West. Our Beacon of Hope Award, Ms. Fayola McIntosh. Our Gideon Award recipient, Freed Frank Harris, Shriver, and Jacobson, which will be accepted by Peter Simmons. Our mock Supreme Court Justices, Anirudh Bansal, James Benjamin, Carrie Cohen, Dan Gitner, Catherine Goldstein, Sharon Cohen Levin, Kelly Moore, and John Nathanson. I want to thank Michael Keston and Appeal Tech for the beautiful First Monday journals. NYU, please, clap it up. They are beautiful. NYU for allowing us use of this wonderful space and the upstairs. Our honorary First Monday co-chairs, Roy Reardon and Myrna Felder. Our first, yes, please. Our First Monday host committee, Antonia Apps, Nick Burton, Sean Hecker, Katya Justin, Lauren Moskowitz, and Jeff Udell. The entire OAD Board of Directors, all our generous supporters, and my extraordinary colleagues at OAD. Thank you. And now it is my pleasure to introduce this evening's Master of Ceremonies, Jeffrey Toobin. Jeff, please. You already know him, but I'll introduce him anyway. Jeff is the Chief Legal Analyst for CNN Worldwide and a staff writer for The New Yorker. He is a New York Times best-selling author and one of the most widely recognized and admired legal journalists in the country. Please join me in welcoming Jeffrey Toobin.
Thanks, Christina. Hello, everybody. How's everybody doing? What a nice event. Everybody's looking good here. Now, I am going to take advantage of my enormous power as Master of Ceremonies to depart from the plan a little bit, because today's a day that we celebrate justice and the people who do justice and the people who work every day. And there's someone here who that I just think we want to celebrate and recognize, and that is the former Attorney General of the United States, Loretta Lynch. See, I like all about this. So, welcome to the Office of Appellate Defender's 26th Annual First Monday October Gala. Tonight we have come together to celebrate and support OAD, an organization whose innovative model of indigent appellate defense representation upholds the rule of law and responds to the United States Supreme Court's admonition from several decades ago, I don't know if they still believe this, there can be no equal justice where the kind of appeal a man enjoys depends on the amount of money he has. That's pretty dated, don't you think? By combining powerful and effective in-court litigation with education and training, parole and reentry support, and systemic reform advocacy, OAD works to erase the unconstitutional line between rich and poor and ensure that its clients receive full and equal access to justice. It is therefore my privilege to serve as OAD's Master of Ceremonies this evening and to recognize the exceptional work that the lawyers and staff of OAD do every day, to celebrate the extraordinary careers of my friends and former EDNY assistants with me, Faith Gay and Judge John Gleason, who will still be called Judge forever, even though he now represents the United States District Court for the District of Debevoise and Plimpton. And to honor Fried Frank's commitment to the promise of Gideon v. Wainwright, one of those old cases, and to pay tribute to the accomplishments of Ms. Fayola McIntosh. As Christina mentioned, the card, which is in your program, gives you a quick and easy way, but not as quick as your phone, to support the amazing work being done by the Office of the Appellate Defender. So please take out your phones or write on the card or do whatever to make a contribution. And our evening will begin with the presentation of two awards. Christina Swarns, the President and Attorney in Charge, will present the Beacon of Hope Award, and Nicholas Borton, OAD's incoming board chair and the managing partner of Sullivan and Cromwell's Criminal Defense and Investigations Group. Boy, you have to be in a lot of trouble to be able to afford Sullivan and Cromwell Criminal Defense and Investigations Group, will present the Gideon Award. Then I will return and embarrass people further. Christine.
Last year, for the first time, OAD introduced its Beacon of Hope Award. This award celebrates a former OAD client whose life stands as a powerful example of the human capacity for resilience and highlights the importance of centering the administration of criminal justice around the inherent potential of every person. OAD's 2009 Beacon of Hope Award goes to Ms. Fayola McIntosh. Whose work ethic, commitment to family, and absolute refusal to be defined or limited by a felony conviction stand as a powerful example of how human character can and should break down prison walls and overcome barriers of stigma. Ms. McIntosh is the proud mother of a 22-year-old son. She works as a gas mechanic for Con Edison. She holds an associate's degree from Nassau County Community College. And 13 years ago, she was charged with assault after an altercation in a Manhattan nightclub. After 2 trials, Ms. McIntosh was convicted of second-degree assault and sentenced to 5 years in prison. She held a full-time job as a unionized construction worker at all times during the pretrial and trial proceedings. But after she was convicted, she was immediately sent to prison. OAD was assigned to represent Ms. McIntosh on appeal, and citing her family relationships and work history, we immediately secured her release from prison on bail pending appeal. And what did Ms. McIntosh do when she got home? She went back to working and taking care of her family. And although OAD won Ms. McIntosh's appeal in the appellate division, that decision was reversed by the Court of Appeals. As a result, Ms. McIntosh had to once again leave her job and her family and go to prison. But prison did not change her. Instead, her work ethic and her love of family became the keys that unlocked the prison doors. Ms. McIntosh worked just as hard in prison as she did when she was at home. She worked in the Bedford Hills nursery, taking care of newborn babies. She completed education and training programs, including college courses. Ultimately, she so impressed the people around her at Bedford Hills that she was awarded additional merit time and was allowed an early release from prison, an unheard of success for a person convicted of a violent felony in New York State. I don't have to tell you what Ms. McIntosh did after her release from prison. She went home to her family, and she got back to work. She started out working construction, and then she applied for a position with Con Ed. That application was denied because of her felony conviction. But Ms. McIntosh knew she could succeed at Con Ed, so she turned to OAD for help. We connected her to the Community Service Society, and they, with our support, urged Con Ed to reconsider Ms. McIntosh's application. They did the right thing. Con Ed gave Ms. McIntosh the chance she deserved, and she has been working for them ever since. In fact, in the spring of this year, Ms. McIntosh was promoted to the top level in her trade. Because she stands as a powerful example of the fact that a criminal conviction is never the most defining aspect of a human life, it is my great pleasure to present OAD's Beacon of Hope Award to Ms. Fayola McIntosh.
Ooh, I am extremely nervous right now. Good evening, ladies and gentlemen. I am honored to accept this award, not just for myself, but as a beacon of hope for all the offenders that has overcome the many barriers we are faced with upon transitioning back into society. As offenders, we are only recognized, as offenders, we are only We only receive a glance, if that, of our accomplishments. That represents our future and not what we are capable of. So much emphasis is placed on our past that if we do not find strength deep within, it can become a highly discouraging road to travel. I cannot speak for everyone that has been a part of the judicial system, but my past does not define nor represent who I am. Looking back, I could remember a member of the parole board saying to me, "You are labeled a menace to society, and if it was left up to the judicial system, I would make you carry out every day of your sentence." Needless to say, he was a man of his word, and he tried to make me do just that. However, his word stuck with me for a very long time. What he didn't know is I had already made it. I had already deemed myself a winner in my mind. I promised myself that as long as I had control over my destiny, I would never prove him right. I went through some trials along the way. I suffered through some overbearing adversaries, but I stayed in the fight. Instead of tapping out, I tapped into my inner strength. And on September 20th, 2019, my supervisor handed me and my crew a job packet and said, "You have to respond to a gas leak on Rikers Island." My heart sank, and I could not even hear myself think or hear him talk for that matter. But when I approached that bridge, I knew that I had beat all the odds that were against me. And no matter what bumps and bruises I suffered along the way, I proved that the opinion of the judicial system, the opinion the judicial system held for my future was wrong. I crossed that bridge as a winner, with my mind and my body unshackled. I am a college graduate, a productive member to society, and I'm at the master level of my trade. I have so many people to thank for their support, and without my support system, I don't know how I would have made it. So I would like to take this time to thank my family, my friends, and the members of OAD for helping me pull through my adversaries. And I would also like to thank everyone in attendance tonight. Thank you and have a good night.
Good evening, everybody, and that's going to be a hard act to follow, but it falls to me. As Jeff said, my name is Nick Borton, and I'm the incoming chair of the board of OAD, so let me add my welcome to everybody for coming here tonight. Contrary to what Jeff said, our rates are not that expensive, I just want for the record. It is my great pleasure tonight to award OAD's Gideon Award. The Gideon Award honors a law firm that has demonstrated an exemplary commitment to indigent appellate defense through its participation in OAD's Volunteer Appellate Defender Program, what we call the VAD program. Through the VAD program, OAD partners with New York City law firms on OAD criminal appeals. It's a fabulous program. It offers law firm associates the opportunity to represent indigent defendants in criminal appeals of their felony convictions, working under the supervision of OAD supervising attorneys. It really is a one-of-a-kind opportunity for young law firm lawyers to both perform a critical and much-needed public service and to get, at the same time, on their feet experience arguing criminal appeals. For many, it's the first time they've had a chance to do that. This year's Gideon Award winner exemplifies a deep commitment to that program. Fried Frank has participated in the VAD program for more than 20 years, and in that time span has handled 74 VAD cases. They've had a number of notable successes, including one in 2015 in the case of People versus Cruz, where Fried Frank and OAD convinced the First Department to reverse a client's conviction on the basis that the police arranged show up in that case had been unduly suggestive. The partnership in that case was so successful that Victorian Wu, one of the Fried Frank lawyers who represented Mr. Cruz, went on to join OAD and is now a senior staff attorney. So it is my pleasure tonight. It is my pleasure tonight to award the Gideon Award to Fried, Frank, Harris, Shriver, and Jacobson. Accepting the award on behalf of Fried Frank is Peter Simmons, a litigation partner at Fried Frank, and even more importantly, a member of OAD's Board of Directors for more than 10 years. Congratulations.
Thanks. I'm going to keep this very brief because I know that I'm the last guy standing between you and the main event tonight. As Nick said, we have been fortunate for many, many years, pretty much since the inception of OAD as a firm, to be working with the organization. The VAD program that we've been very active with is not only a good opportunity for associates, but as I've told now generations of associates, more critically, if you think about OAD's mission, it's a chance to participate in an essential part of the criminal justice system, not just to provide representation to indigent defendants, but to make sure that the system works. That even if the facts are against the defendant, to make sure that everyone gets a fair shot, that the DA, that the police do their job appropriately. There are no shortcuts, and that's a very essential part of what OAD does, because not all cases are winners. It's great when Christina can get up here, Nick can get up here and talk about wins, but it's a win every time we can help ensure that the system adheres to the principles of law that we all count upon and that our fellow citizens count upon. And that is an equally essential part of what OAD does, is making sure that there are no shortcuts and that the ends don't justify the means. So, with that, I will get out of your way, and we will move to the main event. Thank you very much.
Okie doke, it's almost time for the argument. But first, I'm going to tell you about some of the facts of the case. And like a lot of big landmark cases where the legal issue is very important and somber, the facts are really kind of bizarre here. Here it goes. Okay, the name of the case is Altitude Express versus ZARDA. Now, what would a business called Altitude Express do? Well, they're a skydiving company. Right? Donald ZARDA worked as a skydiving instructor for a company owned by Altitude Express. His job was to take customers, as one does, on tandem skydives, which required Mr. ZARDA and all instructors to be strapped hip to hip and shoulder to shoulder to his customers. Because of the close physical proximity, the skydiving instructors frequently made jokes, including jokes of a sexual nature and or references to sexual orientation to break the ice. In June of 2010, it takes a long time to get cases to the Supreme Court, Mr. ZARDA told a customer that he was gay and had an ex-husband. The customer, however, alleged that Mr. ZARDA touched her inappropriately and disclosed his sexual orientation to excuse his behavior. Mr. ZARDA was fired soon thereafter. There's going to be a quiz on all this later. Mr. ZARDA filed a lawsuit in federal court claiming that his firing violated Title VII of the 1964 Civil Rights Act, which prohibits discrimination because of sex. And obviously sex is the key word here. The district court granted Altitude Express's motion for summary judgment on the Title VII claim, concluding that then existing Supreme Court precedent held that Title VII does not protect against sexual orientation discrimination. So the question is, what does discrimination on the basis of sex mean? A three-judge panel of the Second Circuit agreed, relying on the same precedent, holding that Title VII does not prohibit sexual orientation discrimination. However, the Second Circuit, sitting en banc, overturned its prior decision and held that Title VII does prohibit discrimination on the basis of sexual orientation. The majority of the full court explained that sexual orientation discrimination is a subset of sex discrimination, that it is based on assumptions or stereotypes about how members of a particular gender should behave. including who they should be attracted to, and that such discrimination constitutes prohibited associational discrimination, meaning that the employer is taking an action based on opposition to association between members of particular sexes. The dissent, on the other hand, emphasized the fact that sexual orientation was not contemplated by the drafters of Title VII in 1964, that Title VII only prohibits discrimination that treats men and women differently, and that sexual orientation discrimination is not rooted in sexism. Altitude Express filed a petition for writ of certiorari, and that is what brings us here today. Now, a few logistical announcements. First, there will be no intermission. Second, after the argument, I will return to the stage to present the Gould Awards for Outstanding Oral Advocacy and the OAD Council for Justice Award. Immediately thereafter, we will observe the secret, but actually not secret, deliberations of the mock Supreme Court. But the one thing we can be sure of is it will be done by 9:15. So now, please join me in the mock Supreme Court of the United States as I invite the court crier, Myrna Felder, to open our session.
Okay.
Go get him, Myrna.
Okay. Please rise. The justices of the mock Supreme Court of the United States. Oh, wait a minute. Here we go. Oyez, oyez, oyez. All persons having business before the Honorable mock Supreme Court of the United States are admonished to draw near and give your attention, for the court is now sitting. God bless the United States and this honorable court. Please be seated. Thank you.
We'll begin by hearing case 17-1623, Altitude Express versus Melissa ZARDA. Ms. Gay, are you prepared to proceed?
Yes, Your Honor, I am. May it please the court. Chief Justice West. God, there's a lot of you. I think I'm going to go back to my day job, arguing with child court. Anyway, may it please the court. Title VII advances equality in the workplace by prohibiting employers from considering artificial, arbitrary, unnecessary personal characteristics that have no relevance to their jobs. And one of those, as we know, is sex. One of the things that is clear about this statute is that an employer cannot discriminate because of sex. Through this express language, viewed in the most conservative possible lens, that of biological gender, Title VII prohibits discrimination based on an individual's sex characteristics or sexual relationships if those identical characteristics and relationships would be acceptable if that employee was a different sex. This text-based conclusion does not require the court to add a new protected category to Title VII. It simply asks that this court heed Justice Scalia's admonishment, speaking for a unanimous court 20 years ago and giving every word in because of sex its full, fair, and expansive scope. My client, Donald ZARDA, alleges that one of the reasons he was fired by Altitude Express, and it only needs to be one, was because he was romantically attracted to men. If he were Donna ZARDA, as opposed to Donald ZARDA, a woman who was attracted to men, he would not have been fired. Altitude Express would not have said that he had disclosed not so great things about his personal life. It would have been fine if he'd been a woman. So under the plain reading of Title VII's text, Donald ZARDA has pleaded that he, as an individual, not a class, suffered workplace discrimination because he was male and would have been treated differently as a female for disclosing the fact that he was gay and had once been married.
So, Ms. Gay, I just want to make sure I'm understanding. Are you essentially saying that sex means the same thing as synonymous with sexual orientation in the language of the statute?
Not at all, Your Honor. Sex is not identical to sexual orientation, and we're not arguing that. It's not identical to sex discrimination. What we're saying that Mr. ZARDA, as a gay man, because he was attracted to men
and because he was, and that he was in fact both a man attracted to men, that those two facts, those are sex factors, and he was therefore discriminated against because of sex. We're not saying that sexual orientation is the same thing as sex. We're saying that sexual orientation is a subset of sex discrimination and comes under the broad language of Title VII, which says because of sex.
But Ms. Gay, isn't your example changing two factors? You're changing both the sex and sexual orientation of the person. So you're comparing a homosexual man to a heterosexual woman. Isn't the more apt comparison a homosexual man and a homosexual woman, and whether or not they're treated the same?
Well, Your Honor, under Price Waterhouse, the simple test, and which, I mean, it's been adopted in several cases, but to use the most recent one, Price Waterhouse, you only change the one factor, which is the person's sex. You do not change their conduct. So it would be changing more than one factor to change from male on male sexual interest to female on female sexual interest. The one fact that you change is the person's sex.
Counsel, you cited our precedent in Price Waterhouse. Wasn't that based on gender stereotyping? Meaning you don't get into gender stereotyping. And here, as I understand the underlying factual record, is gender stereotyping is not only that it was a stereotype that men should like women and women should like men, but that this underlying trial was only cited that men wore pink clothing. Counsel, I'm sure you know a lot of men that wear pink clothing.
I do, Your Honor.
Where's this film now? I'm sure wearing pink and blue tie. So that can possibly be a reason for gender stereotyping.
Your Honor, I agree with you. And as happened in the ZARDA case in the trial court, the pink fingernails, pink all things pink fell out of the case. But what was left was the simple fact that Mr. ZARDA disclosed that he was gay and he had an ex-husband. And on that issue alone is what has come up to this high court on the theory of sex discrimination and whether sexual orientation discrimination is a part of that. And I would suggest, Your Honor, that what people feel about gay people, the prejudice they feel about gay people, is Exhibit A, is the most pervasive kind of sex stereotyping one can imagine. And to that extent, Price Waterhouse is right on point. And Price Waterhouse requires, just to be clear, that what you do to decide whether sex has been involved is the discriminator here, is you simply evaluate the fact pattern, the characteristics at issue, as if the plaintiff's gender had not been taken into account.
But other statutes that deal with this prohibit discrimination on the basis of sex, and they specifically say, and on the basis of sexual discrimination, of sexual orientation. So if we hold that because of sex has included sexual orientation all along, which I think is what you're
Yes, Your Honor, that is what I'm advocating.
Wouldn't that introduce superfluous language in the other statutes?
Well, Your Honor, as this court has held in numerous cases, comparing the language of one statute to another is not the primary way that one should take a look at the statute. You look at the statute on its own four corners. But to answer Your Honor's question more fully, the very fact that another statute says sex and sexual orientation or says gender discrimination, there's a number of things it could say besides this incredibly broad.
Counselor, I'm sorry to interrupt, but my esteemed colleague's question, this statute, for example, says race and color, both in the statute.
Right.
It does not say sexual orientation.
No, it does
So why
not.
are you asking this court, and how should this court expand what is clearly not in this statute?
Well, Your Honor, again, it doesn't say sex discrimination. It says because of sex. And again, there's no requirement that you compare one statute to another, especially statutes that were passed much later than the 1960s.
May I ask a question along those lines? Would you agree, Counselor, that the question before the court is one of statutory construction?
Yes.
And if we are trying to read the statute to find in it the intent of the Congress that passed the statute, how can we get there, given what I think is really undisputed evidence that Congress 55 years ago was not thinking about sexual orientation when they drafted the statute.
Well, Your Honor, respectfully, I would say that that question is irrelevant to what we're looking at now. As Justice Scalia in the On-Call case said, for a unanimous court, the provisions of our laws, the principal concerns of our legislators are not what we're worried about at this point. We are worried about the actual language of the text. This is a pure case about the text and about sex.
But with that in mind,
Yes, Your Honor.
in 1964, the Congress used the term sex, and in your papers, you said that, and agreed, that meanings of statutes are fixed in time. What's the basis for thinking that the meaning of the word sex, put aside the intent of Congress, embraced sexual orientation in 1964?
Well, Your Honor, as I say, I don't think it's relevant whether or not that was the case or not. Maybe it wasn't the case, and I would be happy to concede in talking about these issues today that it wasn't the case. But as Justice Scalia said in On-Call, that is not the issue. The issue is what the plain language of the text says. And if I may, this court has expanded the interpretation of because of sex in a number of ways. It's had to make a number of corrections to the Court of Appeals over time. For example, sexual harassment is not in the text of the statute. Male-on-male sexual harassment, which is the subject of On-Call, as Justice Scalia mentioned, was not something that was ever even anticipated or could have been anticipated in the 1960s. That's not what people were thinking about when they wrote down the word sex. So I would say that maybe that your question might have had more relevance half a century ago, but not near, Your Honor.
Although, Counselor, I'll note Congress did amend the statute to include pregnancy discrimination. And that status, I think we would agree clearly, is a function of sex. So how are we to know what comes from the language of the statute and what requires Congress to make clear? And perhaps you could address the fact that we are told that there have been over 50 bills that have been considered and rejected by Congress that would have made the language plain.
Well, Your Honor, I'm glad that you mentioned the 1991 amendment, because the language of that amendment made it very clear that the added language was not solely and exclusive, that it was including but not limited to. I would say that the couple of thoughts that would be most relevant to what this what because of sex means now are this court's own precedents giving guidance over time to the courts of appeals and moving with the evolution of what we understand to be sex discrimination in this country over time. Because as I say, I don't believe there's any way in the 1960s that we thought, for example, male-on-male sexual harassment would be included. In terms
Ms.
of
Gay, I'm sorry to interrupt, but
Sure.
Isn't the purpose behind the language because of sex in Title VII to ensure that women and men are afforded equality in employment opportunities? And doesn't your reading of the statute address really a different purpose, a laudable purpose, but a different one, to promote equality between gay and heterosexual employees regardless of the gender? So isn't this something that should be left to Congress to expand, something Congress has, as my fellow justice has noted, has chosen over and over again not to do?
Well, Your Honor, just to twin those two questions together, if I may, the fact that Congress hasn't acted over 50 times, nothing can be drawn from that, as this court has repeatedly said. If we felt that we could draw something for Congress not acting, we would have to think that Congress was totally in favor of gun violence now. They refused to act over and over and over again. But
That's a little different. Right?
Is it?
I mean, well, like,
Chief Justice.
It is. I mean, whether or not Congress has failed to act in total is a little different than what the justices have asked. They've asked in specific instances when the word sexual orientation would be added to the statute, Congress has repeatedly refused to do that. So the question that I think we need to have an answer to is, if Congress has repeatedly refused to amend Title VII to add the very language that you contend exists in Title VII today, what conclusion should we draw from that?
Well, Your Honor, as I say, it is not a well-settled totem of statutory construction to ever look to what Congress hasn't done. There could be many reasons. Congress may have thought the language was broad enough. Congress may have decided it didn't need belts and suspenders here. There is nothing in particular that can be drawn from that. And I would argue at the same time that it's not our place to put a limitation on this particular language that Congress has not drawn as well. Because of sex does not say because of gender. It does not say because of sexual harassment. It does not say because of one sex against another. It doesn't say that anywhere.
The case that you pointed us to a number of times.
Yes, yes, Your Honor.
Essentially says that the critical issue under Title VII is whether members of one sex are exposed to disadvantageous conditions that members of another sex are not exposed to. So how did Altitude Express's conduct here expose a member of one sex that others could not be exposed to?
Well, Your Honor, I would suggest that in the particular case before the court, it's a much easier fact pattern than on call. Because on call, as you will recall, was male-on-male sexual harassment at an oil rig, no women inside, a much more difficult standard of proof than this easier case where Mr. ZARDA says to the person he's strapped next to that he's a gay man and he has an ex-husband. If he had been of a different gender, that would have not been unacceptable statement for him to make that resulted in firing, and needs to only be one possible factor. So that would be my answer as well.
But Counselor, if this is an easier fact pattern, why did our esteemed appellate justices in the Second Circuit have such a problem reaching a decision? You know, their decision, it's 8 different opinions. It's 3 separate rationales. You have concurring justices concurring in part of the rationales, not concurring in others. If it is so simple that because of sex, includes sexual orientation, why is it that we are now reviewing what is, again, with all due respect to the Second Circuit, a fairly tortured decision?
Your Honor, nobody, even the esteemed Second Circuit, can ever get over arguing about sex. Sex makes Americans crazy, insane, and they will parse it to the end. And I would suggest to you, all this heated argument makes my point, because if this is not about sex, what is? If gay prejudice, the prejudice of me, looking at me and saying, the reason I have prejudice against you is because you have a female partner, because you have sex with women.
Isn't the reason that we feel strongly about this is because society has now evolved to a point where we recognize sexual orientation to be among those factors that are, as you say, artificial, arbitrary, unrelated to merit, and therefore should be against the law. But isn't that not really the question? The question is whether under the text it is actually, and in 1964 was intended to be prohibited by Title VII.
Your Honor, you have the question just right, because it's true that millions of people in this country are stereotyped in a way and suffer from homosexual prejudice, but we're not here to talk about public policy. We're here to talk about the breadth of because of sex, that phrase. And the phrase incorporated that incorporates sexual harassment, it incorporates same-sex harassment, it incorporates anything that has to do with prejudice because of sex. And I would like to go back and just make one thing clear, because I think my time may be about up. I'm not sure which one of these buzzers is on. But I am talking in terms of the presentation of the questions to you about the most conservative way you can review the statute on because of sex, which is that you have to show a difference between male and female, and we can meet that test, I'm suggesting. But Title VII does not limit itself to instances where men and women are treated differently at all. It flatly prohibits any kind of individual discrimination because of sex, as indicated in on-call. And it refers to an individual personal response, not a class. If there is discrimination against, one of the things that was raised earlier, between gay men and lesbians, those are two separate prejudices. The two don't make a wrong right. The same way that when anti-miscegenation laws were defended in the Deep South they affect blacks and whites the same way in an interracial marriage, the same thing is true here. Two wrongs do not make a right, and the focus in Title VII of an individual application to the facts, not on a whole class of men, not on a whole class of gay people, but what happened to Donald ZARDA when he made a statement that if he was a woman, he would have still had his job and may still be alive today.
Thank you, Ms. Gay.
Thank you.
Judge Gleason, are you prepared to proceed?
May it please the court, I'm John Gleason. It's such a privilege to follow my colleague Faith Gay to the podium. She's a fabulous advocate, but she happens to be dead wrong in this case. This case is about the breadth of the text of a statute, and the particular text we're concerned about is the phrase "because of sex" in Title VII, which prohibits adverse employment actions motivated by that invidious discriminatory motive. And Your Honors, sex and sexual orientation do not mean the same thing. That was true in 1964. It remains true today. You could ask any of the hundreds of people here, or you could go out in Washington Square Park and actually talk to some normal people, and you get a uniform answer. Sex is not the same as sexual orientation. Sexism, the disparate treatment of one sex as compared to the other, is not the same as homophobia, the disparate treatment of homosexuals, men and women, as compared to heterosexuals.
Judge Gleason, if I can interrupt, I read your papers and they had a couple of dictionary definitions. I happened to look up the dictionary definition of sexism, I think one of the same dictionaries you used. The definition, at least one of them, is attitudes that foster stereotypes based on gender. So why isn't discriminating against certain men based on how they behave as men sexism?
Well, it's sexism if the discrimination is sex-specific and it disparately treats one sex as opposed to another. There was some discussion when my colleague was at the podium of these sex plus cases. Discrimination, adverse employment actions directed not to all men or all women, but to a subset of them with a plus factor. Classic cases are the Phyllis versus Martin Marietta case and the Newport News shipbuilding case. Cases involving discrimination not against all women, but women who have preschool children. They weren't hired. Whereas the same subset on the male side, men with preschool age children, didn't suffer from that disability. They were hired. In the Newport News case, male employees whose families were expecting were provided benefits to which the female employees who were similarly situated were denied.
May I ask a question? You're speaking about these groups of people as groups and as classes, and one of your adversaries' arguments that I found rather compelling was that the cases teach us to look at the employees as individuals, not as members of groups. And in this case, if you look at it from that perspective, focusing on Mr. ZARDA, not on all men or all gay men, but rather on Mr. ZARDA, he was fired because he was attracted to men. If you imagine a hypothetical woman colleague of his who is attracted to men, she would not be fired. Doesn't that make out a violation under the plain text of the statute?
It's not going to surprise you to hear me say no. And Justice Moore got this right. That changes two variables. The proper comparator in determining whether there's discrimination because of sex, when you look at a man who's discriminated against because he's attracted to men, is to look at a woman who is discriminated against because she's attracted also to a same-sex partner. When that sort of discrimination treats, to get back to what I was saying before you kindly interrupted me, Your Honor, that treats each of those pieces of forms of discrimination, treat a subset of each sex exactly the same. It discriminates the same way against a subset of men, that is, men who are attracted to the same sex, as a subset of women who are attracted to the same sex, and that's not a protected class.
Along those lines, Judge,
Yes.
do you believe that Title VII prohibits discrimination against people who are involved in interracial relationships?
Yes.
Okay.
Of course it does.
Doesn't that prohibition treat people of all races equally? Meaning that if an employer discriminated against people who are involved in interracial marriages, it would be treating white people the same as it was treating African Americans, the same as it was people treating Indian Americans and all other races. So all those races would be treated equally, except the employer would be telling them whom they could associate with. And isn't this discrimination against someone who is involved in the same-sex relationship essentially telling people the same thing?
No, it's not. For a couple of reasons, Your Honor. One is, this court has never recognized an associational sex discrimination claim, and for good reason. Because the other cases, those race and religion cases, involve an animus against a protected group. When an employee gets fired because the employee is black and is white and is married to a black person, that represents animus against a class protected by Title VII, race. When an employee is fired, we may not like this, but as my adversary said a moment ago, we're not here to formulate policy. This is a text we're talking about. This is a statute. And we may not like the fact that when an employer fires a homosexual employee, we may not like that, but that does not represent animus against a class protected by this statute.
But doesn't firing a man for being gay ultimately rest on the gender stereotype that a man should be attracted to women? And if that's the case, isn't that enough to say he was fired because of sex?
If it represents a gender-specific stereotype, the stereotype you described is not gender-specific. It's homosexual-specific. It's no question that there can be actionable discrimination alleged by homosexual employees as long as it's based on sex-specific stereotypes. So if a woman is not promoted because she is not promoted because the employer decides, well, you know what, you need to be macho in this job, and women are not macho, so we're not going to promote you. That's actionable.
So, Counselor, isn't that the Price Waterhouse v. Hopkins case that you were just referring to? And isn't that the same as the pink tie and the pink nails example?
No, it's not. That's not a sex-specific stereotype.
But
and the Price Waterhouse case, a little more precisely, Justice Cohen, is the woman who it was determined with respect to that plaintiff that she shouldn't have been as macho as the job demanded. She was disadvantaged in her job because there was a stereotype that Price Waterhouse subscribed to about how women should act that deprived her of the opportunity to become a partner in that firm. She was disadvantaged because she did not live up to a sex-specific stereotype. That's the key.
What about a policy that permits sexual harassment against both men and women? I think we can all agree that that would be illegal discrimination against sex under Title VII.
Yes, and the one thing I will agree with, one common ground we have, is Title VII, the text of that statute can and does and has gone places that the Congress that passed it in 1964 did not have in mind.
So why isn't
the key is that, excuse me.
Why isn't this a comparable evil of the type that Justice Scalia, who didn't always like to stray from the text, even himself recognized? Why is, with all of the intertwined issues between sex and sexuality, why is this not a comparable evil that we can also find is prohibited by Title VII?
Justice Bansal, I think one of the most ironic arguments that Ms. Gay has made here is that the short, uncontroversial, 9-0 decision authored by, of all people, Justice Scalia in En Cal has somehow smuggled sexual orientation discrimination into Title VII. It did not. What Justice Scalia said in that uncontroversial opinion is yes, it may not have been the case that the Congress in 1964 envisioned discrimination against men, sexual discrimination against men, any more than it envisioned race discrimination against whites. It didn't discriminate, it probably did not, most likely did not, according to Justice Scalia, absolutely did not anticipate same-sex discrimination. It's an example of the statute going up to a place that the Congress didn't have in mind, but it can only go places. And the rest of the sentence in which he uses that phrase, that reasonably comparable activity, roots the limits. The statute cannot go to a place the language won't bring it. And the rest of that sentence ties us right back to the language of the statute, which says because of sex. And it may bring the prohibitions in Title VII to context Congress didn't have in mind, but they must be rooted to that statute. And sexual orientation is different than sex.
If we can go back to sex stereotyping, in terms of, and I think you recognize that sex stereotyping, discrimination based upon sex stereotyping is not permissible under Title VII, but isn't the most common sex stereotype that men are attracted to women? And so how is discriminating against a woman, or that women are attracted to men, but how is discriminating against a woman who is attracted to a woman any different than discriminating against a woman because she acts too macho, or she doesn't conform to to a stereotypical way that a female should behave, having her hair done, wearing makeup, etc. Isn't it exactly the same thing?
No, it's not, Your Honor. And it's not because we're interpreting a statute. This court said 5 years ago that when you interpret a statute, you can't let policy get in the way. And if the Congress that passed this statute did not intend to include homophobia as an invidious discriminatory motive, this court can't, because it thinks it's an invidious discriminatory motive, it's an invidious action, import it into Title VII. It's often the case, and I don't suggest for a minute that there aren't cases in which the facts will demonstrate both sex-specific stereotypes, how women should act, how men should act, and also proof of homophobia, of sexual orientation discrimination. But when the jury gets charged, and this happens, you breathe the rarefied air of the Supreme Court of the United States. Some of us hang out in the trial courts our entire career. And every day there are juries in this country that are asked to determine whether or not there's been discrimination because of sex.
Aren't you?
And excuse me. Yes.
But aren't you just creating like a big exception here, a huge loophole that someone can simply argue Mr. ZARDA is fired because he is attracted to men, because he had an ex-husband, but if his employer simply says, I did it because he was gay, then all of a sudden that same activity could not be protected?
Boy, that's a great question, and I have what I suggest respectfully is a great answer. First, if that's true, that's a reason for Ms. Gay to go to Congress and say change the statute. But I'm going to suggest to you, Justice, that that's not true for two reasons. One is sexual orientation discrimination is actually illegal in 22 states, including all 3 states in my circuit where I come from. So if what you're positing is the employer will come up with a pretext, that is, I'm not discriminating based on a sex-specific stereotype, I just don't like gay people, then he's walking right into a state law claim. More importantly, and this is what I meant, this happens every day. Sometimes the pretext is, well, we didn't fire him because he's a man or he doesn't comport with sex-specific stereotypes. We fired him because he was late 5 times. You're suggesting the pretext now would be, we fired him because he's gay. Well, the evidence will show that, well, there's other employees who were late 5 times and they weren't fired. And the jury will decide whether or not that was in fact a pretext. There are
Judge
other
Gleason,
employees who are gay who were not fired. The jury will decide it was a pretext.
Counsel, we're told by the Second Circuit that lower courts in that district are struggling to make the sort of judgment calls that you're describing. They're struggling to distinguish between evidence that is admissible in a sexual orientation, discrimination claim, and sex stereotyping claim. And so the circuit is now encountering circumstances where, for example, a reference to a homophobic slur is only admissible if it's directed at a heterosexual person, but not a homosexual person. I mean, doesn't that sort of illogic undermine the force of your argument? In other words, doesn't it speak to sort of the semantic distinctions that you're drawing?
I got to say that, those lower courts in the Second Circuit have gone to hell in a handbasket since I left. But
That's right.
Not to be flip, the answer to your question is there is no, with no disrespect intended, there is no ambiguity in the difference between sex and sexual orientation. Only in this room would we entertain that possibility because we're lawyers. But there is no such ambiguity. And Judge, when it comes to proof problems and the degree to which a homophobic remark might be admitted as evidence in a particular case, when there's a heterosexual victim as opposed to a homosexual victim, I don't purport to be able to comment on the appropriateness of that without some context. But it doesn't alter the fact that at the end of the trial, if the Title VII that we know was enacted in 1964 is faithfully applied, the jury will be told that it's not sufficient to support a plaintiff's verdict to show discrimination based on sexual orientation. You must find by a preponderance discrimination based on sex, and I assure you, the juries are going to know what you're talking about. They're not going to be.
Judge Gleason, if I could ask, because I'm not sure, based on your argument, your position on this question, can an employer discriminate against both men and women equally in this sense? If the employer requires men to conform to male stereotypes and women to conform to women stereotypes, is that acceptable?
No.
And so why is that different than this situation in which you're saying it's okay for employers to discriminate against both men and women equally because of their sexual orientation?
Because each time, whether it's a man who's the plaintiff or a woman who's the plaintiff, each time that plaintiff has been subjected to an adverse employment action for failing to comply with a gender-specific stereotype, in that specific case, that person is receiving disparate treatment as compared to the other gender, whether or not they are also being discriminated against for failing to comply with a woman-specific stereotype. Each one is treated disparately as compared to the other sex. The fact that you do that, you commit multiple Title VII violations. Two wrongs don't make a right, to borrow an argument from my adversary.
Well, but you're suggesting that, or you're not, that if you only discriminate against men because they're gay, and you don't discriminate against women because they're gay, that would be a violation of Title VII.
That would be a violation of Title VII.
And
because that, if I may, that's not discrimination based on the sexual orientation. That's discrimination based on sex. If you fire all the gay men and have a policy of retaining all the lesbians, that violates Title VII.
Right, but in this case, the only evidence we have is that the employer discriminated against a man because of his sexual orientation, correct?
And there's no claim in this case that there was a set of comparators, that is, lesbians, who were similarly situated, who were not subjected to the same adverse employment action as the plaintiff. If there were, that might make a claim.
So it can't, you're not saying, though, if a workplace has 100 men and 1 woman, that because the woman doesn't have anyone to compare herself to, that she can't suffer an adverse employment action?
No, of course you can. And the comparison thing is just a proof issue. It doesn't affect the text of the statute, but it affects how cases get presented and proved in the district court.
But in terms of looking at the actual text of the statute, the language is because of sex. And in any decision, in the decision with respect to the decision to fire Mr. ZARDA, the decision was because he was attracted to men. How can that, and he is a man, how can that not have at least some component that's because of sex? How could his gender not have been a factor in that decision?
It's understood, and that is at the heart of a, may I finish? I see my time is up.
You may finish.
It's a facile argument that's made by the petitioner. Taking account of someone's sex is fundamentally different from discriminating because of their sex. And I'll give you an example. Employers can maintain separate restrooms for men and women, at least those who identify with their assigned sex. Let's leave the transgender cases out. And it can fire a man or discipline a man who insists on going in the women's room, and it can discipline a woman who insists on going in the men's room. In both cases, the discipline would not have happened but for the sex of the employee. You have to notice it, you have to take account of it. But no one would say that they were disciplined because of their sex. They're disciplined because they're violating the restroom policy. So the simple fact that you have to take notice of Mr. ZARDA's sex to determine whether he's a member of a class not protected by Title VII, he's gay, doesn't mean he's discriminated because of his sex. He's claiming discrimination because of his sexual orientation.
Thank you, counsel.
Thank you.
I have never heard lawyers say sex so many times in my life. My God. So let me just talk about restrooms, because for some reason lawyers also are obsessed with restrooms. It's a red herring. As much as I love my opponent, and I do, whether or not, let's not talk about it. There's maybe a chance in the world that a restroom policy that discriminates between men and women could be actionable under Title VII. I mean, maybe like back in the last century when I was a young associate at a law firm, I won't say which one, and the men's restroom was big and grand and full of cool things, apparently, and the women's restroom, and the women's restroom was on another floor, 5 floors away, which you had to run down to in your high heels and everything else. Maybe there was a claim there, but what we're talking about, the hypothetical Judge Gleason gives you, is not a condition that is material to one's employment. What was material to Mr. ZARDA's employment, what got him fired, was that he made a comment about that he was gay and that he had an ex-husband, which would have been completely anodyne, uncontroversial, a bore if a woman had said it.
Is that an element of Title, what is prohibited and permissible under Title VII, whether something is material to one's employment?
No, but it needs to affect the conditions of one's employment. And I think again, unless it is a particular situation, we have accepted for privacy interests and other things that having separate restrooms, according to sex, would not be something that would affect one's condition of employment. I mean, often the comparison is made that we would never have racially segregated restrooms. And that is a different situation because of the long history and connotations of segregation of the races in this country. But that doesn't mean that we need to talk about and think about these, what are really inconsequential issues. The restroom issue can be brought up right now. We don't have to talk about sexual orientation. If I may, just very, very quickly. I would say that when Mr. Gleason stands up here and says that sexual discrimination and sexual orientation discrimination are not the same, are not the same thing unless you are lawyers, I would say that the real reason is because, I'm sorry, John, that we're not so young. Younger people know that gender stereotyping, as set forth very clearly in Price Waterhouse, that the ultimate gender stereotyping for women and separately for men is to say who they can sleep with, how they can live their lives, how they can conduct themselves. And that is something that Title VII addresses and covers, and because of sex, because that conduct is not relevant to employment conditions. Thank you very much.
Thank you, Counsel. Embarrassing.
Okay. Please rise. The mock Supreme Court of the United States now stands adjourned. The court will reconvene on Monday, October 5th, 2020 at 10 a.m.
Oh, they say, oh, okay. Boy, I don't know about you, but I was sitting there thinking, I'm glad I don't have to answer those questions. They were hard. God. Well, that was great. Thank you to Faith and John. That was really, let's give them another round of applause. Okay, so first I'm going to give the Milton S. Gould Award for Outstanding Oral Advocacy, awarded annually by the Office of the Appellate Defender. First to Faith Gay. Now, Faith and I started at the U.S. Attorney's Office like practically the same day in 1990, and she went on to a great career as an assistant and, of course, as a litigator. And with all due respect to Gleason and John Gotti, Faith and Jerry Roth tried the best case in the history of the Eastern District. She tried and it seems appropriate in this group to tell it, the most gloriously, the most wonderfully, the most horrifyingly corrupt law firm in the history of New York City, the Morris Eisen law firm. And it was a personal injury law firm that Faith and Jerry Roth prosecuted that, you know, just to give you one idea, they shrunk a ruler to 8 inches, but it was still marked off for 12 inches, so that they could put it by potholes and take photographs and make the potholes look bigger. They had a firm softball game where, you know, somebody fell and broke an ankle, and they thought, what a terrible waste of a broken ankle. So they went to Aqueduct Raceway and found a pothole where they said the guy had tripped, so they could sue Aqueduct. And Faith and Jerry tried that case, and I tried a spinoff, and it was just a glorious, glorious thing, and a real tribute to the legal profession that they lasted as long as they did. But Faith went on to great things in the private bar. And now she is a founding partner of the majority women-owned boutique law firm, although it's rapidly becoming less and less of a boutique. It now has more than 100 lawyers, and of Selendi and Gay. She is frequently sought out to represent high-profile corporate clients in civil proceedings, antitrust, securities litigation, contract and financing. But what you may not know is that Faith dedicates a substantial portion of her time and her firm's time to those in need. She co-founded the American Immigration Representation Project to make sure that immigrant detainees have lawyers to help them navigate the new federal immigration and deportation policies. She also litigates appellate and post-conviction cases like those that OAD handles every day. For example, Faith successfully represented Marissa Alexander, an African-American woman who was sentenced to 20 years in prison for shooting at her abusive husband after her attempt to invoke Florida's Stand Your Ground defense was unjustly denied, a case I was pleased to cover on CNN. Faith successfully appealed this wrongful conviction and negotiated a disposition that ensured Miss Alexander's freedom. What you may not even know in addition is that because it's not enough work to start a 100-lawyer law firm, Faith recently received her doctorate in divinity at Yale Divinity School. So when she appeals, she appeals. Through her extraordinary work, Faith has demonstrated that she shares OAD's commitment to full and equal justice for all, regardless of wealth. For that reason, it's my honor to present Faith Elizabeth with OAD's Gould Award for Outstanding Oral Advocacy.
So, one of the great things tonight, besides getting to say sex so many times, is having this amazing group of Eastern District people. I mean, it's great to have the Attorney General here. It's great to have so many of our nearest and dearest. When Jeff and I started in the office, John was already this prodigy who was, prosecuting Gotti. We looked up at him. He looked fabulous. He was cool in court, all those kinds of things, and he's remained so tonight. And John and I have been working maybe for a year and a half on a case together, and I learn things from him every day, and tonight was no exception. So, John, it's a real pleasure to have shared this with you, and also with this amazing court, because these are issues that are huge and scary and incredibly important. And I pray tomorrow goes well in the Supreme Court. And I appreciate the time for all of us to think about it, to take them seriously, and to try to develop the best arguments possible for the right side. So I applaud OAD for taking the time to work on these particular sets of issues, which are very near and dear to me. I'm super happy my wife is in the audience tonight. When the Civil Rights Act was passed in 1964, that kind of thing would not have been said in public unless you wanted to go to jail. It wouldn't have been legally possible. So the case is of enormous magnitude. So thank you for sitting through it. And let me just say that this organization, OAD, is particularly meaningful to me. I've admired it for years. We're in a sort of post-factual environment. People's careers, their lives, their freedom, their chances to be citizens in this country are sometimes eviscerated in a tweet. And what's standing in between all that, of course, is an organization like OAD, and there is no organization like OAD that evaluates the facts, makes sure that we don't stereotype people, makes sure that we don't throw people's lives away when the record and the facts and the law don't justify it. So I'm thrilled that we're here tonight in support of them and that we've had such a great turnout, and I'm honored to share this award with Tony, with John, with Viola, and to help us advance the cause of freedom and justice in this country, as I think Title VII was meant to do. Thank you.
Now I have to give the award to Judge John Gleeson. As Faith mentioned, when we arrived, John was already an assistant. And what I was struck by was the parallels between John's career as an assistant and my career, because he was there for 10 years. He was chief of the organized crime section. He was the person who finally led the successful prosecution of John Gotti. He won every award that the Justice Department can bestow. And I was there for 3 years, and I compiled a satisfactory attendance record. And I just thought we had a very sort of similar experience. But then, it wasn't even all that much of a surprise. It wasn't a surprise to me. Maybe it was a surprise to John that he was named right out of the U.S. Attorney's Office to be a judge in the Eastern District, and he was there for 22 years. And most judges, even really great judges, are they sort of take the cases that come and they do a great job, or they don't. But John really had a project as a district judge. He was the person who tried to make sentencing a more just system in the United States, and over again, he became first an eloquent and outspoken opponent of mandatory minimums in the federal sentencing guidelines, particularly those that produce unnecessarily long sentencings. Unnecessarily long sentences. And he declared, in a famous opinion, that the federal sentencing guidelines were deeply and structurally flawed because of their reliance on mandatory minimums. And he spoke out about the extraordinary human cost associated with the unnecessarily punitive extra months and years the drug trafficking offense guidelines that required judges to impose even on small-time drug dealers. And he reminded his colleagues that we must never lose sight of the fact that real people are at the end of the receiving end of these sentences, and during periods of long incarceration, children grow up, loved ones drift away, employment opportunities fade, and parents die. He also urged prosecutors to think about the ways in which mandatory minimums were distorting the sentencing process and mandating unjust sentences. He had the personal experience and credibility to call out the fact that prosecutors routinely threaten ultra-harsh mandatory minimum sentences so that no one, not even the prosecutors themselves, think are appropriate, and to demonstrate to defendants generally that those threats are sincere, and prosecutors insist on the imposition of the unjust punishments when the threatened defendants refuse to plead guilty. And finally, he recognized that even people who are indisputably guilty of violent crimes deserve justice. With that principle in mind, he urged the U.S. Attorney to remember that prosecutors also use the power to remedy injustice, and that ensuring that a man serving 57 years was reduced to 20 years. And I always remember something John said to me when I was an assistant, and I don't remember how the subject came up, but I remember where we were standing, and we were talking about someone who was, I know, a mentor to John and someone I looked up to a great deal, and that was Eugene Nickerson, a judge on the Eastern District. And John said to me, just sort of looking off in the distance, he said, when you're in front of Judge Nickerson, you really feel like you're in federal court. And I always thought that was a wonderful thing to say about Judge Nickerson. It was a wonderful thing to say about federal court. And I know that when you were in front of Judge Gleason, you really felt like you were in federal court. John Gleason.
Thank you, Jeffrey. That's so nice of you to say that. Thank you to OAD. It's such an honor to receive this award, and an honor to receive it from this organization. The truth is that the criminal justice system tends to treat defendants as though their criminal case is the only thing they got going on in their whole lives, and lives are not cubbyholed like that. People have family court problems, and they've got landlord-tenant problems, and they've got addictions. And the beauty of OAD is bringing holistic representation to people at the appellate level, and that's a goal that I think we should all strive to at all levels of the criminal justice system. So good for OAD. Thank you for honoring me and Faith, and it's so special to be, Faith and I are joined at the hip in this case that she described, so it's nice to be here on a...
We're next guy.
Yes. Yeah, right. And I want to also congratulate the other honorees, Tony. The only person who worked harder to get her award here tonight is Fayola. And you still, yes, so congratulations to you. You're an inspiration to everybody. And of course, Faith and Fried Frank, Peter, on behalf of the firm, accept my congratulations, please. The justices, for a number of reasons, I was petrified tonight, because a couple of these people spent a fair amount of time in my courtroom. And I was a little worried about the world being round and all of that. Emily Hush and Matt Specht are associates at Debevoise. And to the extent I did not embarrass myself tonight, it's because of them. To the extent I did, it's not their fault. And my wife, Robin, is here, and I'm very grateful to her for her support in all things John Gleason. And her parents are here as well, and I'm grateful for that. And one of my daughters, Molly's right over there. So thank you for that. Thank you.
And the final award of the evening goes to Tony West, who is the Senior Vice President and Chief Legal Officer and Corporate Secretary for Uber. You know, you have to wonder, does Tony have enough to fill his days? You know, Uber, it's like this Zen company. Nothing bad ever happens. No drama. It's a good thing there are all these good restaurants in San Francisco, because he can have long lunches there, because, nothing ever happens at Uber. But before he was at Uber, he was twice confirmed by the United States Senate to serve in the Obama administration. Obama was the one before, remember? While there, Tony held a variety of positions, including serving as the third-ranking person in the United States Department of Justice, where he supervised the Civil Rights Division, which used to, for example, exist, the Office of Justice Programs, the Office of Violence Against Women, and the Community-Oriented Policing Services Office, among others. Additionally, when Tony served as the Assistant Attorney General of the Civil Division, he led the Justice Department's review of the constitutionality of the Defense of Marriage Act and successfully advocated for the department to abandon its defense of that now clearly unconstitutional law. Tony's fight for justice did not end when he left Washington. He now holds a leadership position at Uber, where he receives 5 stars at all times. A company that is committed to giving employment opportunities to people with criminal convictions. Uber not only banned the box, it joined 18 other national corporations to join the Obama administration's Fair Chance pledge to improve their communities by eliminating barriers for those with a criminal record and creating a pathway for a second chance. There's other stuff that goes on at Uber too, but it is my privilege today to present Tony with OAD's Council for Justice Award.
Thank you. Yeah, Jeffrey's jokes about the Obama administration would be really funny if they weren't so true. Oh, my goodness. Tonight is a night of firsts. Thank you very much for this. First time I've ever served as a Chief Justice. First time I've ever accepted an award in robes. My great-grandfather was a Baptist preacher. My grandfather was a Methodist pastor. They are now looking down at me saying, he found his way home. Look at him there. No, but thank you, and thank you to the many law firm partners who are here tonight of Uber. This award really does mean so much to me. Anytime you get an award that has the word justice in it, it's a big deal, but particularly from an organization like this, because OAD knows what justice is. It knows what it means. It knows what it means when justice is absent in people's lives and people who become entangled in the criminal justice system. I've been fortunate to practice law for over 25 years, and I was very, very fortunate early on in my career to have a mentor who taught me what justice could look like. As a very young attorney, I was a young, very wet behind the ears, didn't know anything political appointee in the Justice Department, and I had the extraordinary opportunity to work for the first female Attorney General, General Lynch's predecessor, Janet Reno. And one of the things that she always would talk to me about was how much she loved being a prosecutor and how that was such a calling for her. And when I ended up getting a job as an assistant U.S. attorney in the Northern District of California, my home, right before I went back home, she asked to see me one-on-one in her office. And during our little visit, she took me out, and right outside of the Attorney General's private office, there is a little room that's got wood panels, and it's actually a little octagon. And in the walls is carved the quote from a United States Supreme Court case, which essentially says the United States wins its case when justice is done. And General Reno told me in that moment that my job as an assistant United States attorney was not to go out and win as many trials as I possibly could. Although may it please the court, I did win all of my trials. No, she told me, she said, look, your job is to do justice in every single matter that you handle. Your job is to do the right thing in everything that you handle. And that was such a powerful charge to me at the time. I was in my mid to late 20s. It became the North Star, not just for my service in the public sector, but also in the private sector. And it's why this award is so meaningful and so special to me, because folks here at OAD, you do justice every single day in the clients that you engage, in the cases that you handle. Your work really speaks to the aspirations and the expectations we have and expect of a society that is just, that is fair. You know what it means to create a playing field that's level. You know what it means to give people an equal shot at what that justice means. And so I'm very pleased and very humbled and very honored that you would honor me tonight with this award. Thank you.
And now, now we have the rare opportunity to observe the secret deliberations and vote of the mock Supreme Court. Chief, you gotta preside.
Yes. So why don't we take an initial poll before we deliberate to see where the court is on the issue. And Justice Bansal, why don't we start with you?
So I would, should you want just who I would rule in favor?
Yes.
Yeah, I rule in favor of the petitioner. I'm sorry, the petitioner, sorry. No, sorry. The ZARDA.
You can change as we go down the line if you want.
The ZARDAs.
Ditto.
Same. ZARDA.
I mean, I guess I'm boring. ZARDA.
Altitude Express.
All right. That's so. Do we want to have any deliberation on on Altitude Express? Why don't you, Justice? Why don't you share with your colleagues your thought as to why you have such a different view of this case?
I think that while I certainly share my colleagues' view of how this should come out in terms of what we all believe, The statute itself and its original public meaning, I don't think can be contorted to include sexual orientation into the meaning of based on sex. I don't think a reasonable observer in 1964 would understand Title VII to include a ban on discrimination based on sexual orientation. And Price Waterhouse, as we all know, was a plurality decision, not a majority decision of this court, but even so, the analogy of sexual stereotyping, I mean sex-based stereotyping, I don't see how you can convert that in this case. So I don't view heterosexuality as a female stereotype or male stereotype to get you within Price Waterhouse.
Well, there was one question that one of the justices asked, which I thought got to the heart of that, and maybe you can help us understand, which is, isn't the classic sex stereotype that men should be attracted to women and women to men, and once you've granted that, this becomes very much a sex stereotyping case under Price Waterhouse.
I don't view that as a sex stereotype. I don't think, like I said, being gay or heterosexual is a female or male stereotype.
Well, it necessarily has, to be able to even label one as gay or lesbian has to take into account one's sex, doesn't it?
It takes into account one's gender, but I still don't see it as a male or female stereotype.
Does anyone else persuaded?
Doesn't a stereotype mean a traditional view? It doesn't just mean something that is necessarily associated with one's particular trait. So a stereotype, almost by definition, I would think, and maybe I need to look at Webster's for this, but almost by definition would be something that culturally and societally is attached to a particular trait, in this case gender. And I think Sharon's question was a very good one, which I think was Sharon, that isn't the quintessential sexual stereotype, gender stereotype, that you should be attracted to a member of the opposite gender.
And I think the bias, the root of bias against gay and lesbian people is fundamentally rooted in the view that it's fundamentally rooted in opposition to same-sex attraction. So there isn't daylight between the stereotype and the bias. They're mirror images of each other, and I think that helps to cabin what could otherwise be a concern one may have that this decision could be viewed as unprincipled or unbounded. Here you have such a close connection between the stereotype and the bias. I think it helps, for me at least, to fit it very neatly under the Price Waterhouse reasoning.
Yeah, and I was persuaded by the idea that sexism is something that is, evil to be rooted out, and there seemed to be agreement between the parties, and that racism equally, people agreed, obviously, was something that should be rooted out, and that really this is founded on the idea of sexism, which means in this, I did look up as I mentioned, I did look up the definition. I mean, it's fostering.
You weren't supposed to go outside of the facts.
This one's small, but I can't say that I had it memorized. But it strikes me that it really is a case of sexism classically, and by my outside reading. And so it does seem like a fair analogy, sexism and racism, which I think both parties agreed would be something that's outside.
Was anyone troubled at all by the fact that Congress has had the opportunity to specifically amend Title VII by adding sexual orientation and declined to do so?
Yeah, I struggled with that, and I struggled, I thought, also with a point that Judge Gleason made very loud and clear, which is the statute requires disparate treatment on the basis of sex. And that comes through in all the Supreme Court cases. And I think and I'm actually not as persuaded by the sex stereotyping rationale, because I think if you think about this in like the big sort of classes of people, it's harder to get your mind around how the disparate treatment on the basis of sex applies here, because sexual orientation and sex are not synonymous. But where I was really persuaded was looking at these cases through the prism of the individual plaintiff, not as a member of a class, but as a person. And here, this is a man who was fired because he's attracted to men. If he had had a female coworker who's attracted to men, not fired. To me, that's game over. Disparate treatment, text of the statute, you're done.
That was my impression, too.
I was going to say, I agree, and I think that you go back to the plain wording of the statute, and it says because of sex. And sex is inextricably intertwined with sexual orientation. The basic premise is you have to, it's not just notice, but the fact is that what is at issue here is Mr. ZARDA was a man who has relationships and was married to a man. And that is the basis on why he was discriminated against. And that is because that has to be connected to or because of sex. So I think it's all woven in together. It's almost impossible to disentangle the sex from sexual orientation.
Justice Moore looks troubled. We'll give you the last word since you're writing your dissent.
No, I give up.
That's a short dissent. Well, it's 8-1, and I will assign the majority opinion to myself.
So I just want to quickly thank all of you for participating this evening, for coming out to support the Office of the Appellate Defender. I also want to remind everybody about this card. It's in your journals. You take your phone, you put it together, you can do it quickly, and we'll appreciate it on your rides home. Thank you so much. We look forward to seeing everyone next first Monday.